can tighten that or something?
Okay, let go.
Can you tighten that right there?
I did. Oh.
It's fucking down.
Yeah.
Should be good. Let's do it.
Same rotation is locked.
Chinookies here or what?
Come on, look how stupid can you get?
You want this? Is this what they want from me?
Yes, yes.
Oh, maybe you gotta go up and down. You gotta go up and down.
Okay, so are we live now?
All right. Okay. All right, we're live. Hey, welcome to the courthouse. Attorney Steve here. I hope you can give me a sound check. Does this sound okay? Does this sound okay?
2 people are watching, so 3 people.
Thank you all for watching. We are here in Arizona, Maricopa County today for the Jodi Arias appeal. We just got done. We just left that courthouse right over there. You can see the ABC wagon over there. So we just got out riveting appeals arguments from the prosecutor trying to uphold the conviction and the defense attorney, thank you Roxana, and the defense attorney trying to overturn the conviction and get a new trial. Now basically, just to let you know, I ran into a gal in the courtroom and she was a young student asking, she didn't understand the appeals process. Just so you know, the case starts out at the appeals level. The jury hears the case, and then the defense, if they have things they don't like, they can seek to file an appeal, and that's what's gone on here. So we read the briefs the other day. There were about 95 pages on one, about 300 pages on the other. Attorney Steve has distilled this down to just a tiny little argument. So if you want to watch this, we're happy. We got to let this car go by. Okay, good. Safety first, Attorney Steve. Safety first, baby. So it was a great argument. It started out, it was really quiet in there. The burden is on the defense. The burden is on the prosecution to make its case. Now, Attorney Steve always trying to do amazing, wonderful things for you. You know how you always see the courtroom drawings? I tried to make a little courtroom drawings. Can you see that? With my able assistant, Lisa. That's what it looked like in there. We were sitting in the front row.
Right there, front row.
Front row. So I am going to put the link to the live argument. I was not able to link in with the big boys, the big boys ABC over here, ABC 15. You see some officers coming out right now, but so we were able to hear the arguments. However, again, when you walked in, it was so quiet you could hear a pin drop. First attorney that was there today was the prosecution attorney. He sat down, poured himself a couple glasses of water, and then in came the 2 defense attorneys representing Jodi Arias. So if you don't know much about the case, go look it up. There's plenty of articles, but it's basically, in a nutshell, it's about the murder, the savage, brutal murder of Travis Alexander. He was an executive in prepaid legal, and they got into a love affair. I think she thought she was being used. Next thing you know, turned into murder in Mesa, Arizona. So the trial was held here. The defense is trying to overturn it. Now, I'm going to give you just real quick basically it was a 5-month trial for those of you who don't know. And Jodi Arias, in a rare case in criminal defense, Jodi Arias took the stand. Okay, now a lot of defense attorneys will say never take the stand. It's bad news. And I think in this case probably was bad news because she was on the stand for 18 days. And so that gave prosecutor Juan Martinez, if you remember Juan Martinez, gave him 18 days of questioning. And that's a lot, because all you got to do is find some holes or find somebody that doesn't like her, those kinds of things. But Juan Martinez is a big part of this, a central figure, I should say, in this appeal, because he was accused of, is being accused of prosecutorial, let me say that again, prosecutorial misconduct because of different things that he did during the course of the case. So I'm going to tell you about that in a second, some of the things they said he did. And as you know, she is serving life in prison. This was a death penalty case, And I always think, I'm not a prosecutor, but I always think going for the death penalty is tough. Not too many people want to give the death penalty. That's something for you all to debate, post your comments, likes, whatever you want. So, but they are seeking reversal of the conviction, a new trial, and basically in a nutshell saying there was no sense of fairness, there was no due process, it was a tainted trial. And so here are the basic arguments that were being made. First and foremost was that it was a lack of due process because there was a media circus. So imagine this here, you see one or two trucks out here, but on the trial day in trial court, there would have been 50, 100 media all over the place. And one of the key things that I didn't even know, I didn't even see on TV, maybe you didn't either, was Juan Martinez apparently got out and was signing autographs outside. I didn't know about that, did you? Frontline Lisi. Frontline Lisi is here today. Come on in, say hi. She is here helping coordinate the camera work. My beautiful, lovely Lisa. She's my wife. Don't worry, I can say that. Do I think she has a chance, Roxana, of a new trial? Of course she has a chance. I think it's a very, very small chance. Me personally, I didn't hear anything convincing that would have made me think, given the overwhelming weight of evidence, that anything would be overturned, but that's just my opinion.
Did you tell them that they only had 30 minutes each to plead their case?
Yeah, and just so you know how an appellate court case works, this is not in front of a jury. So what you have is you have 3 judges. It's a 3-panel judge, and this one was presided by Judge Campbell, the Honorable Judge Campbell.
She was good.
And they were all great. I love this. Understand, I'm doing this on my time off because I love it, I learn, but I think it's very slim, the chances of appeal. But the interesting wrinkle, I think, if there was any hope for her to get through and get an appeal and a new trial, is this whole concept of prosecutorial misconduct. And what they were saying is that Juan Martinez, if you remember his cross-examination of her and the expert witnesses, he was really going at her. He was coming at her with everything. He was, showing that she was a liar and everything. Yes, that's true. He signed an autograph and took a photo for one lady one time. The prosecutor made clear to point that out, that it was only one that was on the record. So thank you for that correction. Now, but what it was is he was 37 times, I think they said, 37 times, he was asking questions, getting an objection, and the defense was, the objection was sustained. That means it was granted. That means 37 times he was, call it what you want, cited for being argumentative. Now, cited's not really the word, but they said, you're being argumentative. Argumentative means you're being argumentative with the witness instead of just trying to solicit facts. Okay, when you have a witness on the stand, it's supposed to be cordial, not argumentative. It's just supposed to solicit facts. So what the one judge was alluding to today was that, when this happened 37 times, isn't that a lot? Shouldn't a prosecutor know, hey, wait, I'm crossing the line here? And that's the point of debate. So if there is something, maybe the prosecutor crossed the line. And I'm going to show you, if you'll hold this real quick, Lisa, since we're on that topic. But I'm going to show you some of the things they said he did, what they're calling fundamental error or cumulative error, as they're calling it. Some of the things that they're alleging, aside from the photograph. Okay, who took photos with ribbon wearing media types outside of the courthouse? Was that Arias? No, it was the prosecutor. So you were wearing a ribbon wearing media types outside of the courthouse. Who threw evidence onto the floor in front of the cameras during the trial? Was that Arias? No, that was the prosecutor. Who frequently yelled at defense witnesses during cross-examination? Was that Arias? No, that was the prosecutor. This is reading from the defense brief, okay? Who disparaged defense counsel while the trial was being live streamed to the world? Was that Arias? No, that was the prosecutor. Who released trial evidence to the media outside of trial? Was that Arias? No, that was the prosecutor. So you can see all these things. Who harassed defense experts in front of the cameras during cross-examination? Was that Arias? No, that was the prosecutor. Who told the court that if he had his way, he'd be on TV every day? Was that Arias? No, that was the prosecutor. Who wanted the witnesses to be allowed to watch the live feed of the trial before they testified? Was that Arias? No, that was the prosecutor. So these are the things that were being alleged as sort of the a whole litany of things, what they were calling cumulatively. If you look at this cumulatively, it was a media circus because they're alleging that Mr. Martinez was part and parcel of creating a media circus, okay? Based on that, they allege it could not have been a fair trial, fundamentally violates due process, and a new jury is entitled. Now, a couple other things. They argued, this was in their briefs, that the trial court committed clear error when they refused to reinstate panelists. Now, this didn't come up to the day today, which I was talking to the girl in the lobby who was a student. I said one of their main arguments in their briefs, the defense briefs, was that they kicked off 6 women jurors, that this violates equal protection of the law. And so that was never addressed in oral arguments. So I don't think that was gonna be a big thing, but their argument was you need gender neutral reasons for exercising peremptory strikes. Now, peremptory strikes, that's just when you're in a jury trial, you get a right to kick a few people off, okay? And so, but that wasn't discussed, so I don't think that's gonna be a factor. What else do we have here?
But one thing that I noticed when the defense, for Arizona, the attorney for Arizona, that would be
for the state, attorney for the state.
Right. What I noticed is when they were talking about the prosecutor and if he had misconduct and what they should have done and why that, the attorneys kept on going back to saying, but it didn't affect the jury in their decision. And so then they alluded, the judges alluded to the fact, so you're telling me you think that it should be handled in a state bar ethics, like, what do you call it? Bar complaint. And so they were kind of trying to help him in a sense, saying, you know, yes, he did what he did during the trial, but it didn't affect the jurors in their final decision. So I thought that was interesting.
Frontline Lisa, ladies and gentlemen, is she amazing? I'll tell you, one of the best. A couple more things, and we'll get you out of here and get you back to work or wherever you're going today. Get out to play. There was also a hearsay argument that did not come up. So again, I don't think that was one of their 6 grounds for appeal. This did not come up. Something about Arias had grandparents who had a gun, and apparently the grandparents' house was burglarized. And they said, well, this is the weapon, a .25 caliber pistol that the grandparents had filed a police report with Officer Friedman. Officer Friedman was allowed to testify, and there was a question, usually that's considered hearsay, out-of-court statement offered for the truth of the matter asserted. I'm not going to go into that right now. I am going to have a video coming up on hearsay, though. It's really important that you know that. Hearsay and the major exceptions. You're going to have to bookmark and subscribe to our channel. We appreciate you watching. That really wasn't a big deal. So that was an alleged violation of the confrontation clause. We have a right to confront all your witnesses against you, but that didn't come up today, so I'm not thinking that that's going to be a big one. Another argument was, and I found this interesting, not being a criminal defense attorney myself, but an argument about Ms. Arias being forced to wear a stun belt throughout the trial. So I think on her wrist or a stun belt. So if you go too far, I guess it's like a dog collar or something, you go too far and then it electrocutes you. So one of the arguments was, how could you be forced to testify in these circumstances with this crazy prosecutor, as they allege, with this media circus, with a guy out signing autographs, with a stun gun on your thing, and 37 argumentative objections sustained. So they're just saying, in the cumulative effect, Your Honor, this is what was going on. It's not harmless. This is real prejudicial error. And again, so that's really a flavor for it. I have a couple more notes over here, if you would be so kind to hold that. Frontline Lisi, my able assistant / miracle worker. Couple final notes, and if there's no more questions, if you have any questions, throw them out there. We'll see what I can do to answer them. But again, just riveting the tension. You could cut the tension with a knife. I made a note of that because it was so quiet in there. What I found interesting is that, and I tell people, when you go into appellate court, you have your whole speech prepared, but you've got to be prepared because those judges are not going to let you whip through a speech. I've never seen it happen. Maybe Supreme Court, but not even that. You got to be ready to answer those questions because they're going to start firing away. They're going to start firing away at the different cases that you're citing. They're going to ask, how is that case the same as that case? They're going to ask you things about policy. Well, what should we do as a court? How is a court supposed to handle this? What should the judge have done? You're going to get all those kinds of questions, okay? So here, their top ones, and I'm going to just say it here, their top three. The judge said, give me your top three, counsel for the defense. Give me your top three arguments why this should be reversed. One was prosecutorial misconduct. Two was accusations that the experts had a relationship with Arias. Okay, so there was some subtle or not so subtle suggestion by Juan Martinez, the prosecutor, that there was a suggestion that the expert for Jodi Arias had a relationship with Jodi Arias. And this is one of the things they're finding highly improper, what the court talked about, the ethics and the evidence, making arguments with no facts to back them. And Judge Campbell seemed to be a little disturbed by that, and I would too. But that was their second ground, and the third was just the persistent improper questioning of Ramirez. So that was the top three answers the defense gave. A couple things I said were not addressed. One of the things that the defense argued is that you could have sequestered the jury. That would have helped, so they said. And also there was alluding to maybe they shouldn't have had live streaming in the courthouse, but the court noted, we gave you a chance to put your objection in writing. You never did it. You never put your objection in writing that you didn't want a camera until the end of trial. And there was also talk about all the times, this was a big point for the judges, as appeared to me, is that Miss Arias had courted the media by making her own appearances. She had went out 2 times and did her own appearance, and even at the end when she was convicted, she did a court appearance. So that was a big thing, and so the judges were alluding to the fact that, well, why would this be a big problem about the media and the media circus when it appeared that Jodi Arias liked the media? It seemed to be her thing. So that was brought up. The defense said maybe the court was too tolerant against Mr. Prosecutor Martinez. It may have been a little too tolerant. When will we know if the appeal is overturned or not? Thank you for that question. The judge said, very abruptly, they hit the gavel down, and the judge said, we will have a decision in due course. So whatever due course means, it could be 30 days or less, could be 60 days. They make the decisions on their time. That's how it works. What else? Anything else? A couple. There were some lambasting of the prosecutor. Some of the words that the judges chose to use was a persistent course of shenanigans. Was one of the words that one of the judges used, and that he was acting as an actor on stage, loving the publicity. Well, I don't know. Maybe there's some part of that. Is that necessarily wrong? Shakespeare said we're all actors. We all merely actors. But that's it, as we'll find out what's going to happen. Law is a fine line, and just remember the great words of Bruce Springsteen. Down here, it's just winners and losers, and don't get caught on the wrong side of that line. Dr. Samuel said, I beg your pardon, so any relation connection cleared up with the jury on that. Thank you for that. Like I said, I don't want to go into all the details right now. I got to get back to work, but I did want to report to you fresh, right out of the courtroom. So we'll see what these judges say over here. And
my prediction, she's not going to get a new trial.
You need your microphone when you're talking.
My prediction is she will not get a new trial.
And I have to concur. I believe the same way, and I base that really on the overwhelming evidence of guilt, and the defense really did not take any issue with that. And I think they should have maybe pushed that a little bit harder, that, Judge, the evidence of guilt and, was not as strong as they're saying it is, but they really did not hit on that point. So Attorney Steve Live, hope you like the channel. No other attorneys bringing this stuff for you. Just coming here during the middle of my day, giving you some updates. Frontline Lisi here with me. Hope you had fun. Thank you, D. Clifford. Thank you all for watching. I'm glad you love my channel. Tell your friends. AttorneySteveVideos.com. Attorney Steve Videos. Have a great day, and as we like to say,
Carpe diem.
seize the day. I got to get back to work.